to another episode of the After Parties Me, the Jury segment. I am Tam, your host, not your lawyer, but your nosy best friend. And this is where you come to get all your courtroom tea served piping hot. Yes, it is another Saturday live where we will be going over the Karen Reed Trial 1 sidebars, and they never disappoint. So come on in the room. We're going to get started because this is a long video today. We have Jennifer McCabe's testimony on deck, and it's quite a doozy. An hour and 25 minutes long, and with all of my pauses for commentary, who knows how long we'll go today. So make sure you kick your feet up, sit back, get your coffee, join me in a cup of coffee. New merch. So, be on the lookout for that. Join me with a cup of coffee, your tea, however you take it, and let's get to it.
Persons having anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
I enjoyed Miss Reed. I really liked her. I thought we connected from the beginning. She was very easy to talk to. She had MS, I had MS, and there's not a lot of people our age that I personally know that have it. So it was nice to have someone who understood like what I was going through. So we had that in common.
Now, with respect, to either starting with Mr. O'Keefe, was your friendship the type where you would have any sort of discussions about his relationship with Miss Reed or any girls that he dated at any point in time that you were friends with him?
At different points, yes.
And what, if anything, specific do you recall him telling you about his relationship with Miss Reed specifically? Yes.
I'm going to allow that. I'd like to see counsel at sidebar for just a minute, please.
Sidebar.
I need to hear exactly what the response is going to be. Then I'll ask you if you want an instruction.
Your Honor, what my anticipation with regard to both this and when I ask the same question in regard to Miss Reed is really not much at all. In fact, it's really more the negative that I want to get out.
Right. So what do you...
She didn't have the kind of relationship with her to talk about their relationship.
Oh, so you expect just a yes for John and no for... Do you expect her to expand upon her
No,
troubles or anything like that?
not at all.
At some point during the examination, you do expect that?
At some point during the examination, I just expect some conversation that the jurors have heard. Because she was present when the defendant was talking to John O'Keefe about issues with the kid, not enough time to do their own things, that kind of thing.
All right. So you let me know if you want me to give an instruction that this statement just goes to the nature of the relationship.
Based on that offer of proof, I'm not asking for it at the time.
All right.
Thank you.
So, Ms. McCabe, with regard to Mr. O'Keefe and his relationship with Ms. Reed, is that something that you spend any real time talking about with Mr. O'Keefe?
No, occasionally, hey, how are things going? How's she feeling? How's she doing? Very general.
And same sort of question with regards to Ms. Reed, is that a conversation that you had as far as her relationship with Mr. O'Keefe?
Yes, similar. Mm-hmm.
Now, on that evening, if I could turn you back to the waterfall.
Mm-hmm.
May I approach the witness, Sean?
Yes.
Mr. McCabe, I'm showing you a 3-page document discussion with what's happening.
Okay.
just generally speaking, that 3-page document, do you recognize the contents of that?
I do.
Or what do you recognize it to be?
It's my text messaging with John.
So from sort of the early part of the 28th and around midnight through, the 29th, through the entirety of the 29th.
Yes.
Mayor Coach,
Yes.
almost 60.
Is there any objection, Mr. Jackson? Okay.
Sidebar.
I don't have a principal objection to the content, but I thought we were being extraordinarily indiscernible. That's my only issue. I'm happy to use this, but if the Commonwealth uses it, but I don't use similar documents, we will run into the same issues that Mr. Yannetti ran into, that there's an identical document for all the group chats. So I'm happy if the Commonwealth is saying they don't care about the redactions, then I don't care either. But I want to make sure that I'm following the court's orders concerning redactions.
I appreciate that. So there are no redactions of the phone numbers here?
There are no, my apologies. I sort of didn't mean to put any of that kind of, I think some of the information has to be there as far as them being able to recognize and authenticate it. Obviously,
Which the Commonwealth has the burden of, and the defendants just sort of came in.
I would love it. I would love it if we just use clean copies. If everybody could read, I would love it.
what I would suggest, and I think the concern is very well founded as far as, press or media getting hold of copies of exhibits.
Right.
If I could ask for an order from the court that whatever we put in as exhibits or versus whatever is then released, and I'm happy to make the redactions myself. I'm not trying to put that on the court, but just I think it's easier for our purposes for conducting the trial to have unredacted things, and then we can redact the information.
Except if you broadcast it, if you publish it, then the cameras are taking pictures of it and everybody watching TV gets these phone numbers. So that's why I said, one of the reasons I said everything needed to be redacted before it was introduced into evidence. So this is the luncheon break. You can just quickly cross it out if that's what you want to do. But were you planning on publishing this?
I was, yes.
So we've got the luncheon break to redact them.
Okay.
It's fine with me. Again, I'll just put it out there. I can reasonably conduct my examination without publication as long as I can show her clear, which we have copies of. Clear, concise text that would make my life and Mr. Lally's life so much easier. I don't have to publish them.
I don't understand why they don't just cross out everything except the last 4 digits so that people cannot see the entire phone number. Like, let's just make this real simple. They're making it more difficult than it needs to be.
I just need to be able to read them and have her read them, so...
And that's fine too, as long as, do you intend to introduce them?
I do.
A hard copy?
A hard copy.
Do you have redacted hard copies?
We do.
So you've got the clean copy and a redacted hard copy?
We've got both.
That's the ideal way to do it.
That's what I would suggest.
So
The jurors can have the clean copy, and the press can have the redacted copy.
No. Whatever goes to the jury will be for the press. So the clean copy, I thought you were just going to show to the witness and then the redacted copy.
Okay.
That's how it should be.
Even better.
So clean copy so the witness can authenticate them rather than just reading her name like Mr. McCabe was allowed to do. So are you going to be able to do this to be able to complete today's examination?
There really isn't much.
So that's a yes during lunch?
Yes.
Okay, so just so it's clear, that's how we'll do it. Clean copies to show to the witness that the witness can authenticate, and then redacted copy is actually introduced and redacted copies go up on the screen.
Okay.
Perfect.
Everybody's in agreement with that?
Perfect.
All right, I'm going to release them for lunch, and then I'm just going to... I didn't give the digital evidence instruction before Mr. McCabe because I was just frankly trying to move it along at that point. So I'll start the afternoon with that.
Okay, that makes
I'm
sense.
just trying to move it along. Rush the touch.
Actually, great timing. So we'll have you back here at 2 o'clock. And Ms. McCabe, I'll just ask you to let the jurors walk on first.
Court, all rise.
Goodbye.
Okay, so we're still in session?
Just so the court has it, I have an extra copy for the court.
That's what I was hoping for, thank you.
May I approach?
Yes. All right. Thank you. And then, Mr. Lally, you'll be able to make those redactions that are necessary over the luncheon break?
Yes, Rona, I think what we can, and by we, I mean Ms. Gilman, because she's the one who can actually do these things. But no, I think we would be able to sort of take the whole numbers off of it and be able to print new copies without the numbers so that they can be
So
used.
the same version?
Exact same thing,
Therefore,
just with,
authentication, redacted for purposes of admission and publication.
yes,
All
yes.
right. Great, I appreciate that. We'll see you at 2 o'clock.
Thank you very much.
If the defense had done this,
Right, so Mr. Lally, just before,
she would be yelling at them for wasting the court's time, but she's being all nice and sweet with the Commonwealth. Ugh.
before you begin, folks, I neglected to tell you before or during the testimony of Mr. McCabe, and I don't want to keep repeating instructions, but I do want to remind you, when it comes to electronic communications, before you can consider them in your deliberations, you must first find that it's more likely true than not that the person who authored or sent the communication was in fact the person identified as doing so. If you do not find it more likely true than not that the person identified as sending the message was the one who sent it, then you may not consider that electronic communication in your deliberations. All right, thank you. Mr. Lally, go ahead.
Thank you. Your Honor, may I approach?
Yes.
Your Honor, come up with seats to introduce. Well, let me in those pages that I've just placed before you, do you recognize the content of those?
I do.
And what do you recognize those to?
They are text messages between myself and John.
And from sort of specifically that time period of the early morning of January 29 through the morning of January 29?
Yes.
And what's contained in those, is that a fair and accurate portrayal of the content of those text communications?
Yes.
Now, with reference to Mr. O'Keefe, this is someone that you knew and you had his information put into your phone as far as the contact.
Yes.
And on prior occasions when you had contacted, or specifically that morning when you had left the waterfall and you talked to him on the phone, you called him and who answered? You called the contact that you had as John O'Keefe, correct?
Yes.
Okay. Who answered the phone?
John.
Okay. And then the contact that you had put in as John O'Keefe called you and you answered, and who was on the other line?
John.
Okay. Your Honor, may I approach?
Yes.
Almost seek to introduce him and answer.
No objection, Your Honor.
Thank you. And this is subject to what we talked about in sidebar?
Yes, understood.
Thank you. That's exhibit 89. All right, thank you.
Your Honor, with respect to what's now been marked as Exhibit 89, if I could, with the court's permission, publish that to the jury.
Yes.
Mr. Tate, what's up on the screen is that what you had before you as that exhibit?
Yes.
And this is a presentation between yourself and Mr. O'Keefe, right?
Correct.
Your Honor, I'm sorry to do this. May we approach the...
Sure, why don't you take that down, Ms. Gilman? And, thank you.
Number 3. We just got
I
started.
don't want to make this clunky again. I don't have an objection. It's not redacted.
And I wasn't expecting this. Why don't we just jump right into the text messages?
Yeah, I thought,
Okay, I wasn't expecting the beginning. She's already said these texts were between her and John O'Keefe, and you missed a redaction. So if Ms. Gilman can pull it up with the first bubble, for lack of a better word.
sure,
So I'm going to give you the opportunity to just, do you care
no.
if he crosses out the phone number right here and now? It's at the very bottom there.
Just, Your Honor, for the record, as far as Miss.
Hold on. Mr. Jackson, you need to hear this.
Sorry.
For the record, as far as the information that's contained therein, Miss McCabe has changed her phone number as a result of...
It's the idea in general, not
No, and I very much apologize. I didn't realize that was still.
I don't think anybody thinks she did it intentionally.
No, not at all. I just wanted to be respectful.
No, that's great. I appreciate it. So we'll start right with
Okay. Thank you, Mr. Chairman. So, Ms. McCabe, with what's for you and what's up on the screen is the exhibits. There are sort of green bubbles and blue bubbles, right?
Correct.
And can you tell the jury as far as who's communicating which direction, as far as the green bubbles are who and the blue bubbles are who?
Green is John and blue is myself.
And so the first steps, from this debate, if you could just read to the jury as far as from whom the message is sent, what the content is, and then what the time period is.
So John sent to me where to at 12:14.
And to assist you, if you have that in front of you.
Oh, okay.
So the next bubble down is a blue bubble, is that correct?
Correct.
Similar to the one before, can you just read as far as that's, well, before I get to that, so you receive that message from Mr. O'Keefe, you call him, have a conversation, he calls you back for the conversation.
Correct.
And then subsequent to that, could you read the next blue bubble down as far as from whom, what content is, and what time it is?
So this one is from myself to John, and it says here at 12:27. So at that point, I see a car out front, and I text him here.
You testify to as far as looking at the storm door, seeing a car, then sent a text, that was text.
Correct.
And Ms. Gilman, if you could scroll down to that. And ma'am, similar, if you could just, who sent it, what's the content, and what is that time?
I sent to John, pull behind me at 12:31.
And what were you referring to when you said hold on?
So at this point, the car had moved from the prior spot where I originally saw it. So I thought, what is he doing? Why don't they just pull behind me in the, in the driveway?
You just scroll down. And again, with this bubble, if you could read out.
From me to John saying hello, and it was at 12:40.
And at this point in time, as far as, let me ask you this way. When you're sending these text messages over these periodic time periods, what, if anything, are you doing sort of in between?
So I originally went to the front door, saw the car, texted them, then texted John. Then I went back, kind of sat at the table, just either threw my phone probably in my back pocket. And then a couple minutes later, I got up again and saw that the car had moved. So I had sent the pull behind me. And then a few minutes later, I went back to the window, to the front door, I'm sorry.
And when you went back to the front door, what, if anything, did you see about?
So at this specific point at 12:40, when I say hello, I cannot be certain whether they were still out front or if they had left.
And from any of these text messages that you sent, what kind of response did you receive from Mr. O'Keefe after the lift?
None.
Ms. Gilman, if you could, to the next one. Similar to the prior ones we did.
Sure. Jen to John, where are you? And that was at 12:42. Myself to John, hello, at 12:45.
Now, this is later in the morning, and we'll get to that a little bit more in a moment. But at some point, you left the residence of Fairview, you went home, and you were woken by something, and then at some point, you texted John later on that morning, the 29th.
Yes.
You know, the next couple of those text messages that you sent at that point.
Correct.
And you could just, similar to the other ones we used.
Myself to John, please answer at 4:59. Myself to John. Karen is worried. We need to find you at 4:59. Myself to John. Please answer so I know you're okay. 5:04.
May I approach this retrieve? Just generally speaking, ma'am, do you recognize what's contained in that 4-page document?
I do.
And what do you recognize?
The calls between myself and John O'Keefe.
And am I correct that it starts in sort of a ascending order as far as the earliest calls are on page 4 and then the most recent are on the first page?
Yes.
And the phone calls that you were testifying to about before, as far as talking to him on the way from the waterfall to the residence of Fairview, do they appear in those?
They do.
Right, Lorenzo.
Maybe we push people.
Uh-oh. Approach. This is sidebar number 4.
I want Miss Little to hear this as well. Your Honor, I waited until there was at least foundation to establish that this witness is going to attempt to testify from this document. I believe this document is a partial.
If you want to take a look at it.
This is from John O'Keefe's phone.
Is this on the record?
Yes, it is. You have to hold on. Please don't speak to each other. You've had an opportunity to look at this. And what did you want to say, Ms. Little?
This is from John O'Keefe's phone. It's not from Ms. McCabe's cell phone.
That was the confusion. I don't know that she has the foundation to establish that these are actually her calls, given the fact that these aren't her records. I've never seen her cross-examined on John O'Keefe's records. She's always been cross-examined on her own records. So that's my objection.
Do you have any reason to believe they're different?
Yes, they are different significantly.
It can't. I took them from Mr. O'Keefe's extraction. I think she can authenticate. If counsel wants to ask if there are additional calls or show additional calls, certainly he can do that. But what I'm looking for is just, these are the phone calls around the time. I'm not looking to publish them. I'm just looking to talk about when the first call was and when the last call was.
I'll withdraw the objection. It appears that we've got the other side of these, which is going to allow me to use in cross.
You probably have both.
We have both. Right. Thank you.
Okay.
So, Ms. McCabe, as far as the first calls you were testifying about, as far as when you spoke to Mr. O'Keefe on the way from the waterfall to the residence of Fairview, were those contained within those calls?
Yes.
As far as, is there a time that's associated with those calls that you observed in those 4-page documents?
Yes.
And what else?
12:14 and 12:18.
And turning your attention to page 1, that would be sort of the what's in line there. What time is the last call between yourself and Mr. O'Keefe, and who's calling you?
I'm calling him at 5:25.
Thank you. May I approach him?
Yes.
I'll up seek to introduce him as the next exhibit.
There's not, Your Honor. Thank you.
Now, what's depicted in this video, sort of the screen directly in front of you, do you recognize what that is?
Oh, okay.
Yes.
And what do you recognize that?
John's driveway.
As far as what, if anything, do you observe in John's driveway?
John's car and Karen's car.
And where, if you could, using the laser pointer, just direct your attention to where it's.
Why are they letting her testify to this picture? Because this is a police photo. So the only person that's supposed to be testifying to this is the police. This is very interesting that they're allowing this, because normally they wouldn't allow something like that.
And as far as where is Mr. O'Keefe?
Mr. O'Keefe's car and the defendant's.
And where you observe the defendant's car to be, is that essentially where you parked it at that time?
Yes.
No, may I have a moment?
Okay.
Can we just hold it on?
Sure. I'll see counsel at sidebar for just a minute.
Number 5.
I appreciate it. Looks like cooperation between the two of you. I don't think the jury would mind a 5-minute break while you get this stuff done.
The problem is I just realized he's got to have software on his computer to do it, so it'll work.
Okay.
Do you have this on your computer?
Not ready and available. It may take us a few minutes to find it.
I can give them a break. If you don't want me to, I won't, but
Do you have this as a USB? It's in evidence as a USB.
I think it's going to take too long, Judge.
no, I understand if you don't want to do it too.
I don't want to have to go through the machinations.
The Mac.
All right. If you don't want to assist, because frankly, it's not all that helpful to the defense. I respect that as well.
I don't want to go through us having to bring it up. Ours may be different in terms of the type of file that it's saved as, and it just becomes clunky.
Did she say that? I understand if you don't want to help them because it's not helpful to y'all. Ooh. Basically, I don't want to help you to make this exhibit easier to read because it's not good for us. That's what she's basically saying. She has something else on these sidebars.
Okay. But I do appreciate you trying to work together. Do the best you can with this. And if you have an opportunity to work together and she's still on the stand for the Commonwealth and you can assist,
Indiscernible.
so maybe that's something that could be done. So do the best you can. And if you can't, maybe the defense would be kind enough to give you an opportunity to do it. I'm not telling you to.
No, I understand.
All right.
He went and asked the
Jurors, I just want to tell I appreciate counsel trying to work together for this. It's probably going to take too long, so we're just going to make do. We've had enough interruptions today. So.
we've had enough interruptions today.
Now, Mr. McCabe, as far as what you observe from what you can on the screen right now,
The condition of the passenger side tail light is all consistent with what you observed when the parked vehicle there sometime earlier that week.
It's kind of hard to see from this distance.
and just, if you could, lastly, just with the laser pointer, direct the jury's attention to where in the video you see the rear passenger side tail light. It's going to be taken.
4 minutes to 4, I think we're way too much everyone.
I don't think I can get it done in 4 minutes.
All right, jurors, I'm going to, we're not in session on Monday, so we'll come back Tuesday morning. So Tuesday will be a half a day. Someday next week, I might ask you to think about maybe revising some of these Tuesday, Thursdays to longer days, but I'll give you plenty of notice of that. I need to make sure that I'm just asking you to think about it. All right, so please, those same cautions, do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. We'll leave everything here literally, figuratively. Clear your heads and we'll see you fresh Tuesday morning.
You don't look happy today. Alan must have told her to fix her face. Now she starts smiling. Don't worry, we're going to get the next day of testimony. It won't leave us hanging like this. We will get cross-examination.
All right, so I'll see counsel at sidebar about scheduling.
This is just a scheduling sidebar. Sidebar still, I'm counting. It's sidebar number 6.
So it seems like we're going very slowly.
I think slower than everyone would like it.
Stop repeating, okay? and I don't want to cut a defendant's case off, but it was repetitive.
Geez, I cut out the whole waterfall. I cut out everything. It took me a long time to get through the V marks. It took way longer than I anticipated.
So I will often tell counsel my observation of the jurors. You've got co-counsel, so I don't need to tell you.
I understand.
All right, this is the end of week 3, and we're about where I thought we'd be at about a week and a half. Am I wrong on that?
No. I mean, I'd say by my estimation, we're about a week behind where I thought we would be.
All right, I'm going to keep those 3 days off, that Wednesday, Thursday, and Friday. I would like everybody, the beginning of June, we go all day Tuesday and Thursday, because I think now we have to finish it by the 4th of July, which is problematic. Okay, I'd like an idea of next week's witnesses. You don't have to tell me, but I would like an idea. Are you continuing with civilians?
Yes, but I think we're almost at the end of that.
Okay.
So as I said to counsel, after Miss McCabe would be Miss Roberts. After that would be Laura Sullivan and Marietta Sullivan. Likely after that, I mean, I won't say likely because I have to confirm his schedule, but I think Mr. Higgins could be after that.
I assume you might be cross-examining him. Do you expect it to be a long cross-examination?
I do.
I think he's going to potentially be one of the longest witnesses.
Your Honor, after Jen McCabe, and I will tell you Jen McCabe is not going to be short, Higgins and Proctor are the big ones. Other than that,
I assumed.
I think the court may not be able to tell. I'm pretty peppy on my crosses, comparatively speaking. So when...
Peppy.
As long as you leave the commentary out, it'll go much better.
Fair enough.
I'm going to stop you on that.
Fair enough. I've curtailed it.
A bit.
I've curtailed it. But when it comes to Good Sam, the Good Samaritan witnesses, when it comes to experts like the medical experts, the coroner's office, etc., those aren't going to be long crosses. I don't know how long their directs are going to be, but I may make 4 points each and be done.
The experts are generally easier to predict.
Right.
One thing I can suggest, and I'll just put it out there for counsel, I think personally from Good Samaritan, I get away with just Dr. Rice, who's the attending. He deals with both Mr. O'Keefe and the defendant. Very limited with the...
You know, I think part of what's frustrating me about this whole commentary that we're listening to right now is that she's acting as if the defense is the problem and that they are the reason why things are taking so long. But she is sitting there and watching these witnesses be combative, not wanting to answer questions, not answering the questions directly. And so those things delay questioning. If you don't just answer the damn question and you beating around the bush, I don't recall, it's going to take longer. And that is just what it is. Sheesh.
defendant, I would say, though. And then I have Dr. Fowler, who is the director of the lab. I think I can get everything I need in regard to the blood from him.
You are not peppy.
It's not particularly difficult for Mr. Lally to lay that foundation.
No, I get it. I understand.
No, but in deference to your objection earlier, I did not let him put it into his opening.
Understood.
But it's fairly pedestrian.
Understood.
So I'm thinking, as far as the RN and the PA, I don't think they have any sort of direct involvement with that. It would just be a phlebotomist, but I think everything that I can get from Dr. Fowler is also the director of the lab, so I think I can cut those two out. And I'm looking to see what else we can, as we go along, to try to move this along a little bit.
I can't see.
Okay. I'd like advance notice of when, if you're calling Trooper Proctor when that might be, there are evidentiary issues that I'm concerned with. You don't have to tell me now, so.
Yeah, if you can consciously make an effort to cut out, people know what the house looks like. They know the number of doors, they know the layout of the kitchen, the same with the baths, so jurors are much more interested.
She is, she is acting like she's in the minds of the jury. And she's like, yeah, you could cut all of that out because people already know what they're looking at. And how does she know they know? How does she know they'll remember this is a long trial? I think every time you get a chance to put that house up so that you can see all those different entrances, is good for the defense, and she knows that too. That's why she don't want them to keep showing it. That's why she don't want them to.
In the testimony when it's new to them.
Of course.
All right. Thank you all. We'll see you Tuesday.
Thank you, Your Honor.
Thank you, Your Honor.
All right, to the court, please.
Your Honor, I want to present this delicately and at sidebar, given the nature of the topic here. We've let this go for about a month, and we feel the need to bring it to the court's attention that continually throughout this trial, the O'Keefe family and supporters who are directly facing the jury in this trial have been making faces, rolling their eyes, sighing, swearing audibly, and essentially giving input that the jury is readily able to see in light of the fact that we face them.
Who specifically? Because I've been looking around the courtroom and I haven't seen it. So who specifically, if you can?
I think it's been multiple members. It's been most egregiously John's mother, Mrs. O'Keefe, and it's been caught on camera. We're not looking for them to be admonished publicly. In fact, just the opposite. Our request would be that a court officer address this issue with them to, let them know that they cannot be giving their reactions that they're giving in light of the fact that they're seeking a neutral jury, and their behavior is contrasted with that of the Reed family, which has given no reactions whatsoever. So that's our request.
John, mother!
I don't know that I agree with that last part.
Well, so you must have told Jim because he mentioned it to me. So I asked the court officers, and that's part of their job to watch. And they're saying that they're seeing a little bit from both sides, but it's nothing any greater than any other trial. And I will then ask the court officers to pay extra close attention to make sure that there's none of it.
Okay.
All right. I did ask.
Great.
And, I know Ms. Reed's family is behind you, so you don't see them. And you see the O'Keefe's family because they're next to you.
Of course.
All right. Are you all set?
Yes.
I want to tell you guys that this thing became a big thing, where John's brother, Paul, I think in trial 2, I don't think in this trial, but in trial 2, I think he is no longer allowed to even sit on the front row there, because that's him right there where you see his hands folded. That is John's brother, Paul. He was being so agitated, if you will, in the gallery that they wouldn't allow him to sit on that first row anymore. They said like he was staring Karen down in like a threatening manner, like it. And one of the jurors complained. It wasn't the defense. It was one of the jurors that was like, "This is too much," and they ended up moving him. So, that's just to say that this complaint was a very valid complaint, and I don't know why the courtroom is set up like this. It's strange, but whatever.
You had a clear and good view across that lawn to the SUV, didn't you?
When it was straight out, I did, yes.
You had a clear and good view of that SUV the entire time until it left, didn't you?
I could see the black SUV, correct.
Nothing was obstructing your vision.
I wasn't looking at the ground.
I didn't ask you about the ground yet. We'll get to the ground. Nothing was obstructing your vision, was it?
No.
So you had a clear and good, your words, not mine, a clear and good view of the SUV.
Yes.
And everything in front of it.
I never said everything in front of it. I saw the SUV. It's black. It has lights on. And as it moved, I could see it. with its lights.
And you had a clear view of everything between you and the SUV. All the things closer to you and the SUV.
I wouldn't say that.
So your view was obstructed on what was between you and the SUV, but not obstructed on the SUV?
That's not what I was saying.
No, of course not. Because if you had a clear field of view to the SUV, you could see everything in front of it as well, meaning between you and the SUV as well.
If I'm looking straight out at an SUV, I'm not looking down at the ground.
Let me ask you a question about that. You're focusing right now on my face.
Yes.
As you're answering these questions. You think you'd see, I don't know, an alligator sitting in front of me if it was there?
Objection, Your Honor.
Yes.
You think you would see something? Can you clearly see that there is nothing between you and me except a podium?
Yes. Well, there's a table.
And you don't have to look down to see that, right?
Correct.
You're looking directly in my face, but you can see things that are between you and me because you have a field of vision, right?
Objection.
So I'm going to see counsel at sidebar for just a minute.
What's the objection?
As far as I don't understand the relevancy of what she can see in a lit courtroom versus what she can see when she's looking outside.
Okay, so it's relevant, so I'm going to sustain that, but I don't like demonstrations without some heads up beforehand. Are you almost done with this?
We're up
Almost.
8.
I have.
It's argument, Mr. Jackson.
It's not, Your Honor. This is cross-examination. This is such a huge point.
What do you intend to do?
I simply need to have acknowledgement her field of view is unobstructed. And using myself as an example is not argumentative. It's obvious. It's a point of cross-examination. Every single time I get into it with, and he's doing it for strategic purposes, I get it. But when I get into it with them and I'm getting at making points, he stands up and objects to try to undermine those points and is becoming obstructive and abusive. This is cross-examination. I should be given a little bit of leeway.
You've been given a lot of leeway. I called you over here because having said argumentative, indiscernible, he did not, but it is argumentative.
Yes, Your Honor.
Baby, you see they was struggling to defend this lady. Struggling. They fighting against law enforcement.
As you looked over that flat lawn with that good and clear view of the SUV, you could see the SUV and everything between you and the SUV, correct?
When I looked out the front window, I could see the SUV clearly, like I'm looking at you right now, and it was further away than you are.
And you did it not once, not twice, not 3 times. You did it 5 times, and then a 6th after it was gone, right?
Correct.
And after that SUV was gone, and you looked out that window with that clear and good view, there was no body, was there?
I never saw a body.
Thank you.
I wish I had.
Sounds like that's a little rehearsed.
Not at all. It's not at all.
I'll let the answer stand.
Sounds a little rehearsed.
May I?
Yes.
Thank you.
I'll take, so we don't get mixed up, I'll take a little bit back.
Okay. Thank you.
He probably
I
can't.
want to show you one more document that you weren't shown on Friday. Do you recognize this one?
No.
Okay. If you look where it indicates on the left column, I'm just putting my thumb here, the
Okay.
left column, the MSISDN user, there's a number that ends there. 0142, 0142.
Your Honor, may we approach?
Yes.
So I'm going to answer this question before we approach.
I have no idea what we're approaching about. This document?
Yes.
When did we just go up there?
Sure.
May I have that, please? I know we need to look at it.
This is 9, guys. 9. We're not even halfway through the video.
Oh, excellent. Thank you. Can I give this back to the witness?
Huh?
That one's redacted. This is not.
I'm going to give back Which one am I marking for identification?
The redacted one.
Thank you. Okay, so do you have a copy, Mr. Lally?
I do, but not with me.
Okay, all right. So
My issue, Your Honor, is they've shown it to the witness, asked her if she recognized it. She said no. So then reading from what the document says, when it hasn't been authenticated, I don't know what we're doing.
Well, I'll tell you what we're doing. This is a little bit of a ridiculous objection.
So those commentaries don't advance the ball. So just tell me what this is. Was this
It's her own extraction.
okay?
He showed her and authenticated John's extraction.
Okay, so
And I'm showing her her own extraction, which is going to be compared to John's extraction. And if we can do this the hard way, I can get it done, I think.
so the ridiculous comment doesn't advance the ball. If you had told me first that this is what I saw as an exhibit in the federal grand jury minutes, right? But I reviewed them yesterday.
Yes, Your Honor.
Okay, she doesn't have to.
She is constantly slapping them on the wrist. I mean, these are grown people and they are allowed to express themselves. She doesn't want him to have any feeling about anything. She just wants them to behave like robots, and they are frustrated. They're annoyed. Quite frankly, they're pissed off because they see what's happening and she knows that, but instead she punishes them for not doing what she says. It's just ridiculous.
Authenticate this, right? But you're going to tell her that it's her phone number or point her to her phone number?
I am.
My guess is she will. If she doesn't, you can object and we'll take it from there.
So my anticipation was showing her the last 4 digits of her phone number, as it were, and I can use the unredacted. It's the last used under that number. And then the Apple ID is going to be her as well.
Okay.
I redacted the Apple ID just so I could enter it if I need to, but I can ask the court to use her. The court's unredacted copy just to lay a foundation if need be.
I have extra copies as well.
Go ahead, Miss Little.
All right, so I'm going to allow this and see where we get.
Okay, thank you.
I'll allow it. Come on, Miss Little. She said, I got copies. Crap.
Your Honor, just for ease of maintenance, may I approach and handle
Yes.
an unredacted version?
Yes.
Same thing.
That's why he objected, because he knows that it ain't the same.
Thank you.
Them text messages he just showed
If you
her.
look on the left column, Ms. McCabe,
Yes.
you'll see something that says Apple ID.
Yes.
Look to the right of it. You recognize that unredacted portion? I don't want you to read it out or anything. You recognize that?
Yes.
Whose Apple ID is that?
That's mine.
Okay, if you look, 6 lines below that, there's a full phone number. Again, don't read the phone number out. Just tell me if you recognize it.
I do.
Whose is that?
That's mine.
Okay. May I approach, Your Honor?
Yes.
I'll take the unredacted copy back.
Okay.
So we don't get it mixed up. Does this appear to be celebrated extraction of your phone records, your Apple ID?
Yes.
Okay. And you recognize, without telling me what it is, you recognize that phone number as your phone number back at the time and the Apple ID back at the time?
Yes.
Associated with the phone that you then turned in to law enforcement, correct?
Correct.
Okay.
Come on, Alan, get her.
You've just looked at the extraction report for John O'Keefe's phone, and you saw those calls between your phone and John O'Keefe's phone after going from 1214, after that, all the way up to 1250, correct?
Correct.
Take a look at the last couple of pages, page 3 and 4 of your own cell phone extraction report. And tell me if you see a single call listed between you and John O'Keefe for January 29th between 1214 and 1250.
There are calls to a number that I'm assuming is John.
What
I'm
time?
just not sure. I see a call at Wait a minute.
Wait a minute. Oh my goodness, what is this?
This report has times everywhere.
Right. It's chronological except for the calls that were deleted. You see a call at 5:52 to John O'Keefe's phone.
I see a call at 5:52, yes.
But there is not a single call before 5:52 a.m. between 12:14 and 12:50 a.m. Is that right? Not one.
It's very hard to this report
I can't see it.
trumps time-wise.
You can look at every single time on the report. There's not that many.
I'm just trying to say that it goes from 7:21 to 5:52 to 7:33 to 7:49. There's no order. They're out of order.
I understand that, Mr. McCabe, but if you look at every one of the entries, there's not a single entry for 12:14, 12:18, or any of the subsequent 12:29, any of the subsequent phone calls that are all shown on John O'Keefe's phone extraction. Would you agree with that?
Correct.
May I approach?
Yes.
Wait,
Thank you.
wait. Is he saying that there are phone calls on John's phone from her, but none on her phone to John, meaning she deleted the call? Is that what he's saying? Oh.
Court is now open. You may be seated. Judge, we'd like to adjourn.
Well, I understand counsel wants to see me, but can it wait? Can we get started with the testimony? It's already 9:15.
We can with regard to 3 of the 4 issues, but with regard to one of them, it requires to this witness's testimony.
All right, so I'll hear from Mr. Jackson about that since it's this witness. Why don't we come over here and do it while we bring the jurors in, okay?
She don't want to talk to them. This is
I really just like to get moving if we can. So there's one issue. It will be fine.
Super brief. The court has some impounded phone records that we've never been provided.
Okay.
I just want to go through about 12 or 13 calls that are only in those phone records.
They're right there.
That's it. So if you could just make those available to me and unimpound them for purposes of... They're unimpounded with regard to the attorneys anyway. We'd like to make copies of those so that they'd potentially be highlighted or used. There's about, well, maybe a dozen calls in here that she's not going to know unless she is presented with records. So I just want permission to use these with her.
You can use these.
Okay, but it looks like... So let's mark these, please.
All right. So you can use this original, but before, if you put it in evidence, do you intend to put something in evidence?
No.
I was going to say it looks like there's a lot of redactions that need to be made.
Some were to refresh her recollection or see if she adopts them.
Okay. Is there any objection? Only Mr. Jackson.
I'm sorry.
No.
Okay.
It would be a lot easier if I had permission to highlight. If you want me to ask Miss Little to make a copy real quick, we've got a copy machine right there.
Yeah, so we can't highlight.
Okay. Then while I start with the witness, she can just, if she has permission to leave counsel table and just make a quick copy.
Sure. And then when you finish with this. So I noticed yesterday, I think you asked for one of the exhibits before it was raised. I don't have a problem with that, but the exhibits are to stay with the clerk.
Understood.
So for this, for what has been marked O for identification, you can make a copy, Miss Little, and you'll need both, correct? The unredacted, or are you just...
No, I just need the copy.
Okay. So then if you could give it back.
Sure.
To Mr. Clerk.
No problem.
I'm ready.
what the devil?
You are unmuted.
May I approach?
Yes.
Exhibit 98 from the record.
Does that cover more than what you covered yesterday?
Exact same document. I just failed to do it yesterday. My fault.
All right. So is there still more? I'm just curious if my form's different then.
Yours should be the exact same.
Why don't I take a look at the exhibit, please? Why don't you come to sidebar, please?
Girl.
My apologies, Your Honor. I should say no objection other than the repeated objections that we made as far as.
So you're not waiving any objections that you made. So there were some that you didn't cover yesterday. And I'm just wondering if there's an objection from the Commonwealth. I checked off the ones that you specifically went over with her. Are there others that you...
Wait, so she's basically telling him that he should object? I want to point out to you guys that this lady been on the stand for 3 days. The 14th, 15th, and 16th days of this trial was this witness, because well, first of all, she is important. She's an important witness. On the morning that John was found, Karen called her saying John never came home. Where is he? Oh my gosh. She's screaming and hollering. And Jen is like, come get me. We'll go look for him. And Jen wanted to go straight to 34 Fairview. And Karen wanted to go straight to 34 Fairview. But Jen was like, no, let's go back to John's house, which is weird because Karen just left John's house, so she know he's not there. They go back to John's house. I don't know what they do there. Look around. I guess they lifted up some pillows. Maybe he hadn't under the pillow. And then they went back to 34 Fairview. And as soon as they get to that street and start approaching the house, Karen sees his body and jumps out of the car screaming and hollering. And it's just funny that she sees him instantly, because all of those people left that house that morning and say they didn't see him. Good morning, Mandy. So it's just really funny that she sees him in the snow blizzard going on. She sees him instantly. Oh my God. And she jumps out the car and she's screaming and hollering. But all those people left that house the night before when there was no snow on the ground and they didn't see him. So, whatever. Yes, the judge is working for the Commonwealth.
You didn't like that were beyond, I put them in groups. So not all of them were covered, but if there's not, that's why I was wondering if you're putting in the whole document, even though you don't cover them.
I am, because she indicated that all of it was correct, although I didn't highlight some of them because they're, quite frankly, sort of irrelevant.
Okay.
But I haven't indiscernible. Jurors seen all of it because it's all part of the same.
So that's why I just wanted to make sure we're all on the same page, because there were several that were highlighted. You were on the same page with, if it's coming in, all these come in?
Sure.
So I'll quickly just remind them of the digital evidence instruction.
Thank you.
Thank you.
Yes. All right, so that will come into evidence, and jurors, sometimes I do have to repeat myself a bit, but this is, again, before you can consider any electronic communication in your deliberations, you must first find that it's more likely true than not that the person who authored or sent these messages was, in fact, the person identified as doing so. If you do not find that it's more likely true than not that the person who is identified as doing so was the person who authored or sent or transmitted the electronic communication, then you may not consider that electronic communication in your deliberations. So, all right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Ms. McCabe, you'll recall yesterday we talked about the 12 times in your grand jury transcript that you talked about statements that you attributed to my client. You remember that conversation?
Yes.
And in those dozen times, you never used the word or the words or the phrase, I hit him, correct?
Correct.
And your explanation for that was, well, I wasn't asked that specific question, correct?
Correct.
You were, in fact, on January 29th, let me rephrase that just a little bit. You did, in fact, on January 29th, seek to ask an officer to come back to 34 Fairview for the specific purpose of telling that officer something that you thought was important, correct?
Correct.
Which officer was that?
Michael Lank.
And about what time did you ask Officer Link to join you back at 3430?
I'm not sure. I know it was in the AM. I'm just not sure what time exactly.
Somewhere around 9 a.m. Does that sound about right?
Possibly.
Okay, so this literally we're talking about just a couple of hours after the incident in question.
Correct.
Okay. Sergeant Lank came with Sergeant Gallagher, I believe, correct?
Correct.
Came back to the location at 34 Fairview and gave you an opportunity to provide whatever information you deemed relevant at that time to impart to him, correct?
Correct.
And isn't it true that at that time you didn't tell Sergeant Lank that my client said, I hit him? What you said was that my client said, I hope I didn't hit him, correct?
No.
May I approach, Your Honor?
Yes. Come on and approach her.
Could you take a look at that report, just the face page, and tell me if that appears to be an incident report associated with this case? I know you didn't draft it, but you recognize that that's an incident report from the police, Canton Police specifically.
Yes.
Could you turn to the tab that's the light blue tab, maybe 3 pages from the end of that report?
Mm-hmm. So tell me what you read.
Yes.
I'd like you to read that paragraph to yourself, if you wouldn't mind, please.
Read it to me. I want to hear it.
Do you have that in mind?
I do, yes.
Okay, may I approach, Your Honor?
Yes.
Thank you.
Yeah.
What you read just now appears to be a report of the incident in which Sergeant Lank came back to 34 Fairview to give you an opportunity to tell him whatever it was that you thought was important, correct?
Was that a full report or is that just an excerpt from it,
Well,
that paragraph?
That right there is a full report of that incident of Sergeant Lank going back to 34 Fairview. Would you agree?
Well, that's not a full report of what I said, but if that's his full report, it's his full report.
Okay. And in this report, what he writes that you said to him.
Objection.
The objection sustained.
Isn't it true that what you actually told Sergeant Lank when he returned is that while driving around with her and Roberts looking for the victim, Miss Reed said something to the effect of, quote, I hope I didn't hit him, end quote. Isn't that what you told him?
Yes, because she said that when we were driving around.
And then you went on to say that, quote, she, Karen Reed, made these statements again at the scene when the victim was discovered, correct?
Correct.
And then you went on to say, she, Karen Reed, that you thought that Reed may have made these same statements in front of a police officer, but she was not sure, meaning you were not sure, correct?
I was not sure if she made what the police officers may have heard. That report is his recollection. My recollection is I told him that she said, I hit him, I hit him, I hit him. And I told him that he should ask the responders if they heard that, because it was a great possibility that they heard it as well.
But none of that, you'll agree, you just read the report, none of that is in his report.
Okay, so I'm pausing right here because I want to remind you that the responders that she's talking about is the Alberts, which is her brother-in-law and sister, daughter, her niece. Friend is the responder that she's talking about, who said the exact same 3 lines. I hit him, I hit him, I hit him. And all of them were saying this exact same thing in this trial. And so she's like, so for her to be like, you should ask if she heard it, McLaughlin, because she knows McLaughlin is going to corroborate her story because they probably already got their stories together. Oh, hussy.
It's a very brief report.
I didn't ask you if it was brief. I asked you if it was in it, correct?
Correct.
And that's a report of a conversation that he had at 34 Fairview with you for the specific purpose of memorializing what you told him, correct?
Correct.
And what you told him, according to Sergeant Lennox, is she said one phrase, I hope I didn't hit him, correct?
That's what's in the report.
All right. And again, this was 2.5, 3 hours after the incident. Not 2.5 years later, correct?
Because she don't want to
Correct.
nothing.
May I approach?
Yes.
Nah, the report is accurate. She's just a liar. That's what it is.
Having looked at this set of records, does this appear to be an accurate reflection of the phone calls that you shared with Michael Proctor at some point on and after January 29th?
Yes.
Just to summarize those, and I don't want to belabor this, but there was a call on the 29th at 10:55 a.m. with Trooper Proctor, correct?
Correct.
There was a call on the 29th at 12:49 p.m., correct?
I didn't memorize them.
I understand.
So if you want to give me the paper back, then I could probably answer correctly.
You want to do
Okay.
it that way, we certainly can. May I?
Yes.
Thank you.
Girl, answer the daggone thing.
Thank you.
Thank you.
Okay, first call, January 29th, 10:55 a.m. Trooper Proctor calls you for 1 minute and 17 seconds.
Correct.
Next tab, January 29th, 12:49 p.m. Trooper Proctor calls you for 1 minute and 8 seconds.
Correct.
January 30th at 9:51 a.m. You called Trooper Proctor, 4-second call, probably a voicemail or something.
Correct.
January 30th, a minute later, 9:52 a.m., you then called Trooper Proctor again, 21 minutes and 31 seconds for that call.
Correct.
January 30th, same day, 4:45 p.m., Trooper Proctor calls you for 9 minutes and 43 seconds.
Nah,
Correct.
what was they talking about?
January 31st, the next day, at 11:51 a.m., you called Trooper Proctor for 2 minutes and 53 seconds.
Correct.
That is the sum of those call logs, correct?
Correct.
Can I approach?
Yes.
Those aren't all the calls that you had with Trooper Proctor. That didn't stop. It's just where these logs stop, correct?
I'd have to see my further call logs.
Do you believe that you've had additional phone calls with Trooper Proctor after that last call on the 31st?
I know I did in 2023.
Okay. In 2022, did you have additional phone calls with her?
I'm not sure. I'd have to look at phone records.
Girl, stop.
May we approach briefly?
Okay.
All right. This is number 12. Sidebar.
I did not realize this, but these calls end on February 1st. There should be additional call records, which I'm not going to worry about. It's too laborious.
Okay.
That go through all of February, all of March. I'm just going to ask her about those. If she doesn't remember them, she doesn't remember them. But I didn't realize these are not the full panoply of calls. The court probably has them, but these aren't it. So that's okay.
That's what the court has.
There's nothing else.
As far as my recollection, that's what I received.
We have notes that we took from the ones that were in the court's possession that go months after this.
So we have one of our associates come and look at the court file. He couldn't take them, but he actually scribed notes that go all the way through March. So I know they've been in the court file. Your Honor, I honestly don't want to...
I'll ask Jim to go see if he can go find them.
I mean, I would love that, but I don't want to bog this cross down any further. It is important.
Jim,
Yes.
it appears that there may be additional impounded records. Could you call down and see if there are, or go down and see if there are?
There's about 700 impounded stuff.
No, that came in with this.
All right. That's
Wait. Do y'all think that this is an honest mistake? Or do you think they were trying to hide some of this? Tell me in the chat what you think.
the only thing that came in. That
Oh,
It would have been that same batch. They all came in that one. It should have been in one on both.
It appears they've been misplaced then. Your Honor, with the court's permission, I'll just go ahead, and like I said, I don't want to bog down the cross. I'll go ahead and forge ahead.
okay.
Forge ahead.
So do whatever you want to do, but Mr. McDermott is leaving the courtroom now to go look.
Okay.
All right. So I'll give you back this.
I want to know what those records
Inventory.
say. I want to know. I want to know. I like to know.
May I inquire?
Yes.
Thank you. Ms. McCabe, I don't have the records in front of me. They'll be found before the end of our conversation. But in the meantime, for expedition, do you remember a call on February 14th with Trooper Proctor lasting about 17 minutes?
I don't know.
Do you remember a call on February 17th?
What was they
lasting about 2
talking on
minutes?
Valentine's Day?
I don't know.
Minute.
Do you remember a call on February 28th lasting about 2 minutes?
I don't recall. Again, if it's hard.
I expect that your answer is going to be I don't recall, but I want to make a record if I could. So this is not a test of your memory at this point. I don't expect you to have it memorized. I just want to ask if maybe one of these stand out in your mind, or all of them. What about a second call on February 28th lasting about a minute?
Don't recall.
On March 1st, another call with Trooper Proctor lasting about a minute.
I do not recall.
Apparently a second call on March 1st lasting about 2 minutes and a few seconds.
I don't recall.
On March 11th, another call in the afternoon lasting about 12 minutes.
I don't recall.
And finally, a call toward the end of March, March 29th, lasting about 4 minutes.
Again, I don't recall.
Okay. Understood that this is not a memory test, and I don't have the records in front of me, so I apologize about that. Based on the conversation that we've just had, does that jog your memory that you had multiple calls in February and March with Trooper Proctor, as well as the calls we've gone over with the records in January?
To be honest, I had calls with many people. I was in a state of shock for months following this. So if you have the record, I can answer off of that. But besides that, just reading them to me does not jog my memory. I'm sorry.
That's okay. You wouldn't quarrel with the idea, I don't want to hold you to a number, you wouldn't quarrel with the idea that you had multiple calls with Trooper Proctor in January, in February, in March, correct?
Well, the ones I've just saw on the record, yes, there were multiple calls there.
And of course, you met him in your home on January 29th.
Yes, I did.
And he came into your living room, you had a conversation with him.
In my dining room, yes.
I'm sorry, your dining room. And also, Carrie Roberts was there.
Carrie Roberts was not there.
On the 29th?
Carrie Roberts was not at my house on the 29th, no.
When was she at your house when she was interviewed?
I believe that was the Tuesday, whatever the date was.
Maybe first? Does that sound right? First or second?
Yeah, something. It was the Tuesday following.
Okay. And was that with Trooper Proctor or a different trooper?
A different trooper.
And with Trooper Proctor on the 29th, when he was interviewing you in your dining room, that was the day that Brian Albert was also there.
Correct.
And was Brian Albert also interviewed on that day?
I believe so.
So Trooper Proctor was in your house for, gosh, it had to have been an hour.
She don't recall that either.
Again, you've been shown what's been called a Cellbrite extraction report, correct?
Yes.
Are you familiar with how many Cellbrite extraction reports were conducted in reference to your phone?
I think a couple. I'm actually not sure.
And prior to January 29th, 2022, have you ever seen a Cellbrite extraction report?
No.
As you sit here today, do you even really know what that is?
Not really, no.
Do you know what a wall file is?
No.
Do you know what an SQLite database is?
No.
Do you know what a knowledge profile C database is?
No.
Do you know how information is stored and kept within your cell phone?
No.
Now, as far as, let me ask you this, you had 4 children and you were a mom, a homemaker, correct?
Correct.
At some point you did work though, right?
Yes.
What did you do for work?
I was an elementary school teacher.
What grade did you teach?
5th.
One question and we'll see where this goes.
What grade did you teach?
5th.
And how long did you teach 5th grade?
Objection.
Yeah, I'm going to see counsel at sidebar. Folks, feel free to stand up.
This is Sidebar 13.
So why don't you tell me your objection?
Relevance.
Where are you going with this?
It's going to the fact that she has no familiarity whatsoever with Celebrite, phone extractions, or anything of that like.
Sure.
She's had no prior experience with
You
it
already
personally,
answered that
professionally, or anything else.
I'm not sure that's the way to do it.
I don't think it is either. He's trying to humanize her and make her this little school teacher.
Yes.
It's completely irrelevant.
So you can do that other ways, but not that she was an elementary school teacher.
Okay.
I can take you back to
Martin Luther King.
4:53 in the morning is when you get that first call from Kaylee Kerbush. Is that correct?
Correct.
You answer that call, and then the defendant is put on the line, correct?
Yes.
And so, what is the first sort of iteration of the story that the defendant tells you happened the night before?
That they got into a fight. She left him at the waterfall, and he never came home.
And at some point later, you confronted with that you saw the vehicle out front of the house, correct?
Correct.
And so then what is the defendant's story changed at that point?
That they went there, and it changed multiple times. I'm not sure exactly. She said, at one point, oh my God, I don't even remember going there. She was telling other people that he was dead, that a plow hit him. The story changed multiple times that morning.
We asked what she told you. Why they allow
On cross-examination, you were played a voicemail. Do you know whose phone that voicemail was from?
They never said no.
Fair to say that you're on 911 in the background of that phone call, correct?
Correct.
So it wasn't your phone.
Correct.
And there's two other people beyond that as far as Ms. Roberts and the defendant there, correct?
Correct.
Was Kerry on the phone at all that you saw?
No.
And so with reference to the timing of that phone, you had called 911 and you were on the phone with 911 at the time of that recording starts, right?
Correct.
So you had gotten out of the car, you had gone around and then seen where the defendant had run over to Mr. O'Keefe, correct?
Objection.
As to the form, it's sustained.
What had you done before you placed that 911 call?
I got out of the car. I ran behind the car over to the body. I was in a state of shock for a couple of seconds. Kerry and I looked at each other, and I said, I'm going to call 911.
And there was a period of time when you made the call before it connected, and you said you were bouncing around to different agencies, correct?
Yes.
Very happy. Very happy.
You were asked some questions about when you were on scene, and you indicated in your testimony on direct that you heard the defendant say, I hit him, correct?
Yes.
You were also, early in your testimony, had indicated that earlier in the morning, the defendant had phrased that differently as far as could I have hit him or did I, correct?
Objection.
Sustained as to the form.
You heard the defendant make a variety of statements over the course of the morning, correct?
Yes.
And more to my point, as far as you recall testifying at another hearing on the roll in June of 2022, correct?
Yes.
And do you recall being asked some questions specifically about this topic?
Objection.
Allowed. Okay.
Every time they say something, she roll her eyes. This is number 14. 14.
What's the objection, Mr. Jackson?
It's hearsay. I expect that Mr. Lally will say it's a prior inconsistent statement, but it's not because it postdates the original statements. It's not prior to the statement that she was impeached significantly on, so he does not have a right to get in a consistent statement in June of 2023, when all her inconsistent statements were in January, February, and April of 2022.
All right. You mentioned yesterday about her testifying yesterday.
I don't think I mentioned I don't. I could be wrong because it was lengthy, but I don't.
Mr. Lally, what do you say? I'll look for it, Mr. Jackson, if I recall.
It could be my failing memory and age. I don't remember bringing up the June hearing back then on the issue of indiscernible.
On that specific issue, no. But when it comes to the prior inconsistent statements, counsel wanted to introduce prior inconsistent statements. I'm then allowed to rehabilitate the prior inconsistent statements, especially sworn ones under oath.
A prior inconsistent statement has to predate the inconsistent statements.
So what I was looking for yesterday, you mentioned it. Now she's bringing it up today, so prior consistent would be prior to yesterday. I'm just trying to find that testimony. If the Commonwealth doesn't have it, I'm not going to. It's only prior consistent as to yesterday, and you were challenging her on
Correct.
yesterday.
What she said on Friday, exactly. So impeached her with what she previously said to that.
No, I understand. But I thought there was some recent fabrication on Friday, which would give prior to Friday as a prior consistent statement.
What?
I believe that the prior consistent statement has to predate the inconsistent statements. In other words, we start with the foundation of the statement.
And ordinarily it would, except for yesterday, you made it sound like indiscernible.
I didn't. I just said I was very careful not to say you've never brought it up before. I just said on Friday, you said X, but previous to this, you said Y.
And that's what I believed happened as far as there was a specific question about you've never said anywhere under oath or anywhere before those statements that you said on the stand the other day.
That's absolutely not true. I wouldn't do that. That would be malpractice if I did that. I would never say that because I know that she did say that.
Unethical is different than malpractice.
I wouldn't do that.
Oh,
One is much greater than the other.
Understood.
Is
No, I
she
did not
saying
and would not do
unethical?
that. I would not make a false, knowingly false statement that she didn't, indiscernible. I was careful to move around that.
What's the statement you intend to put in, Mr. Lally?
Her statement that's entirely consistent with what her testimony was.
She gonna let it in.
What is the specific statement?
The specific statement is, so there's two different portions within the federal grand jury testimony. It's on page 816, that
It's on what page?
816 is the first one.
All right. Where is that?
Right at the bottom of the page.
Mr. Jackson, I'm going to let this in subject to I will strike it if it's not. But my memory was that the way it was built up about Friday being a recent fabrication.
Okay, I understand.
We'll have time and we can go through and I'll strike it.
Understood.
However you want me to strike it.
Understood. Thank you.
Yes, go ahead.
Mr. McCabe, as I was asking before, in June of 2023, you testified in another proceeding, correct?
Correct.
And you were asked questions specifically about those statements that you heard the defendant say on the morning of January 20th, correct?
Correct.
And do you recall specifically what your testimony was in regard to that portion of your, in regard to those statements?
I don't recall specifics. I know what I know. I know what happened.
I know what I know.
Yes.
Mr. McCabe, is your memory refreshed as to what you said in that prior proceeding in regard to those statements?
Yes.
And what did you say?
What did I say in that? I told them that Karen looked straight at me and said, I hit him, I hit him, I hit him. And I said that there was, I believe, an EMT that overheard as well.
Now, if you recall in that same prior proceeding being asked any questions sort of at different times, the defendant saying different iterations of that same statement.
Objection.
Sustained as to form. No leading, Mr. Lally.
With respect to that prior, that's testimony in that same prior proceeding, what, if anything else, were you asked about statements the defendant made to you that morning?
I was asked what were some of the statements that Miss Reed had made, and it was like, repeat, did I hit him? Could I have hit him? Is he dead? Is he dead? Is he dead? Could I have hit him? Did I hit him? I have a cracked taillight. And then her, I hit him, I hit him, I hit him.
And so with respect to questions, and as far as did I hit him or could I have hit him, and the statement I hit him, those were at different times, correct?
Correct. You like to change words. I just want to be certain.
So, Mr. Jackson, just keep it to questions, not comments.
You were asked just a second ago by Mr. Lally
Who's getting feisty?
if Karen Reed hadn't jumped out of the car, you wouldn't have stopped, correct?
Correct.
Thank you. All right.
Okay. All right, Ms. McCabe, we are finished. Jurors, I'm going to ask you to follow them out like you've done. We'll take a recess, and this one might be a little longer. I mean,
Sure, folding and leaving the notebooks on the floor, all
in an effort to save a little time, why don't I see counsel at Sidebar to find out exactly what you want from me?
From her face. She is cracking up on the inside. This is 15.
It's just easier to start from here. It saves us a little bit. So what am I doing? What are you requesting?
So 3,
Who's your next witness?
Miss Roberts. Right. It doesn't apply to Carrie Roberts. 3 issues. One is we want to renew our objection to providing impeachment material to the prosecution in advance of their witnesses testifying.
What was that? I don't know what you're talking about.
So this court entered a discovery order indicating that we had to identify the documents and other things that we would be using as exhibits to impeach witnesses. As I said, when the court issued the order, the court has the discretion to do that, but we're renewing our objection in light of the fact that the material that we provided to the Commonwealth regarding this unreported on meeting at the Lanks was communicated to Jennifer McCabe so that they could then anticipate and prepare for that cross when they shouldn't be allowed to.
Okay, so y'all, you understand what this objection is about. This is mind-boggling. So the judge, wrote an order before this trial started, saying basically that if they want to impeach someone's testimony, they basically want to prove them to be a liar in this instance, that they have to provide the Commonwealth with the evidence prior to why would I need to do that? I'm helping you to beat me if I'm going to show you the evidence that you should do your own research and know that this person is a liar before you put him on the stand. I'm going to help you. No, I'm trying to save my client's life. This is wild to me. Why
do that? So that's number one.
That was a total surprise to me yesterday. I had no idea that had taken place.
It was a surprise to us.
I had no idea that occurred. So your objection is noted.
And just so the court knows, we had done extensive work.
Wait, she said she had no idea that she wrote that order? Is that what you just said? Jesus Christ.
On the forensic download, and we found the GPS coordinate, and so we discovered it. She had never told it to Mr. Lally. She had never told it to the police. It was a complete surprise, and it was perfect impeachment. And we lost that moment because Mr. Lally took it and presented it to the witness, and she then had an excuse. So the testimony got out, but it was a little disconcerting that our hard work and our impeachment, which was pure impeachment, was being presented in meetings that we had no idea about. And then she gave statements that were not then discovered to us. So I wasn't flat-footed, but I was close to it.
Okay. That objection is noted.
A related objection is the fact that there was apparently a meeting that took place where she revealed new information where Tully was there along with the DA's office, and that was not disclosed to us until she was on the stand yesterday. Our view is that any new statements are inconsistent with her previous statement.
Okay. This should be Mr. Jackson's argument. It was your witness.
I'll let go what he just said.
Okay.
Any new statements, especially as it pertains to Miss McCabe or any witness going forward, if there are interviews, and they may call them prep sessions, if there are interviews or prep sessions that reveal new information or new dialogue between and among witnesses, we should have them. We should have that. We should have a report of every one of them.
That's concerning. What happened, Mr. Lally?
On that, so what we've been doing consistently throughout, and that's part of the reason I have Lieutenant Tully with me when I meet with any witnesses, is any change or any new information or anything like that has been reduced to writing and provided to counsel as soon as we have it.
Lies.
This I wasn't aware of.
That's what I don't understand. When I confronted the witness, she said Mr. Lally had got it to them. Well, that doesn't absolve him of the responsibility that Sergeant Tully has to reduce it to writing and present it with.
To be clear, that was a meeting that occurred while we were on trial. So that was, and I think she was clear on that. Initially, I think she was confused, but I think she clarified as far as there was two separate. There was one meeting where, yes, I was there. This other meeting was she had asked to review her grand jury testimony on day that we were on trial. And that was, I asked Lieutenant Tully to sort of monitor that.
All right. And you said that there was new information that resulted from that, or that the meeting itself was new?
Both. We didn't know about the meeting, and the new information was Lieutenant Tully was provided and clearly provided information about impeachment and confronted her with it. He said, "What were you doing at Mike Lank's house on the 30th?" And she said, "I met with his wife." And Lieutenant Tully didn't ask any follow-up, if you recall that dialogue. And that's just unfathomable. I know Lieutenant Tully well enough. I've read 1,000 reports. He would have followed up.
So he'll be on the stand, so you'll get to cross-examine him with plenty of notice.
Right.
All right. What's your other point?
Then the only other issue is we do expect after Miss Roberts that the Commonwealth will be calling the Sullivan sisters about the Aruba trip. And our view on that is that that evidence is inadmissible. That is bad character evidence. And so we're requesting of voir dire prior to their testimony to parse out what they can testify to and what they can't.
All right. Who's doing that cross?
I am.
Okay, I'm going to stop it right here. I want to tell you that so what they're talking about is that there was Carrie Roberts, apparently, or Jen McCabe, I can't remember which one, but one of them had gone to one of the detectives, one of the investigators on this case. Her GPS data put her at his home. Hey, Tone, good morning. And they never mentioned that, they meaning the Commonwealth. The Commonwealth did not know this information, and the defense found out about it. But because of the judge's order to turn over their impeachment evidence, the Commonwealth went to her with that GPS coordinate and said, "Why were you at Detective Lank's house?" And so then she made up this story that she drove somebody over there and she was in the car the whole time, and she just waited in the car while they picked up the daughter or dropped the daughter off or some such nonsense, right? But the whole point is, if she had been on the stand testifying that, she never went over there, she don't know nothing about that, and then they were able to present her with the aha moment, it would have hit differently on the stand. The judge's order basically messed up the defense's chance to show all of these people are liars. They're all lying for each other. And so now she's like, "Oh, I didn't know that happened." Lady, come on. Anyway, y'all, thank y'all so much for joining me for another Saturday. We had overtime today. Y'all make sure that y'all hit that like button. Make sure that you share this with your friends and family, or strangers. Strangers love me. Listen, until my next stream, I love you guys. And remember, the world has never met another you. Go out and be great in it. Do something amazing this weekend. It's beautiful outside, so go outside and enjoy it. Get some fresh air. And I'll see you guys back here next Saturday. Bye-bye.